The National Prosecuting Authority's legal representative has argued that the then acting Free State High Court Judge Nompumelelo Gusha's lack of understanding of legal principles contributed to her granting a discharge in the Nulane case. The NPA is making that argument in the Supreme Court of Appeal today, presenting evidence on why it believes Gusha erred in her application of the law when she reached that decision. Now, the case relates to nearly 25 million rand spent by the Free State Agriculture Department for an allegedly fraudulent feasibility study from Nulane, which ultimately led to the controversial Vrede dairy project. Now, Advocate Nazir Kassim says the judge did not understand the basic principles of weighing up documents. Take a listen.
If you look at the objective fact, you give probative value to the documents. So all the documents I've referred to your Lordship up until now, your Lordship will remember I referred your Lordship to 5 documents. All those documents are common cause before the court. Now, if you appreciate the regulatory framework, you say, look, I've looked at the deviation. The deviation is hopelessly inadequate on the basis of Steenkamp, all pay. You don't even have to go that far. You simply say, as Judge Motijana said in the one judgment, there's no accord, there's no consistency with fundamental principles. So if you look at the deviation letter, you look at the contract itself, which is common cause, you look at the proposal, which they never disputed, and then you look at the payments. And then you say, well, what difference does all the other documents make? That's the first proposition. But even if you look at all the other documents, they got probative value because it paints the narrative.
Let's stay with the story. Bring in Michael Marchant, who is the head of investigations at Open Secrets. Michael, it's great to talk to you. Thanks very much for coming on. And I'm sure as Open Secrets, you were tracking this case quite closely back in 2023. It was meant to be the NPA's landmark state capture case, right? This was how we would prosecute state capture cases going forward. Of course, then all 8 accused walked free. What do you make of the NPA's assessment now and the argument they're taking to the Supreme Court of Appeal?
Afternoon, Michelle. Thank you very much for having me. Look, I think as you've said in the introduction and just in what you've been saying now, this was an incredibly important case for the NPA. Although it wasn't the largest when it comes to state capture, this 25 million rand contract, it was so important for a number of reasons. The one is that it was the case at the time that the NPA was hanging the extradition request for the Gupta brothers from the UAE. And so their failure to get it over the line, although the extradition fell apart arguably for other reasons, was a huge blow. But I think also quite fundamentally, as you said, it was supposed to be a landmark case. It was also supposed to be a slam dunk case. This was supposed to be one of the easiest that the NPA was going to get over the line. It was a single contract. There were not too many accused. And so when it fell apart in the way that it did, I think it sent shockwaves, I think, through the NPA, but also more broadly through the public's view on what the NPA was going to be able to achieve. Now, of course, as the NPA is presenting their arguments to the SCA, they've argued that that the acting judge in that case was essentially too hard on them. That was too hard on them when it came to documents and the weighing up whether those were authentic enough to be admitted as evidence. And they also have some arguments around one of the state witnesses and how they were treated. I think it's an open question as to whether the NPA is going to have success at the level of the Supreme Court of Appeal. But I think for anyone who watched that first trial, they would still argue, regardless of the outcome, that the NPA should never have allowed themselves to be in this situation, and that the evidence does point to the fact that that first case was not well handled.
I'm just looking at News 24's reporting around the story at the time, Michael, and part of what the judge had to say in delivering her decision was that it was a shame that the state's own financial expert witnesses effectively put the nail in the coffin for the NPA's case, especially insofar as money laundering was concerned. They admitted, according to the judge, that their assessments of the Gupta network's finances was incorrect. And in fact, they conceded there was nothing untoward about the transfers being made, insofar as the Gupta finances are concerned. She also described it, Michael, very damningly, as a comedy of errors.
Exactly. And I think to answer your first question, Michelle, so on this question about the money laundering, what happened in this case is that a huge amount of time was spent showing that the money flowed out of the state. So in this case, 25 million rand was paid to a very newly formed company that then paid 1.5 million rand to Deloitte for the feasibility study, changed that report to favor the Guptas, and then handed it over. And that contract was granted on deviation. And so, as I said at the beginning, I mean, this was why this case was supposed to be fairly simple. But to go to your question there about the financial analysis, what the NPA didn't do enough of, the judge argued, was they didn't do enough to show what happened to the money afterwards. Mm-hmm. And so, for example, what emerged in that case was they argued that one of the Gupta brothers, Atul Gupta, was the person in charge of the ABSA account making onward payments. And that was so central to the money laundering. In the evidence that was presented to the case, the state then had to admit, and the person from ABSA had to admit, well, there were actually other people in control of accounts. And the NPA and the law enforcement agencies didn't submit the correct requests to them in order to verify that it was actually Atul Gupta giving those instructions. Yeah. Now, they weren't saying that it was impossible to determine that, but again, it goes to this question of, did the investigators take all the necessary steps to get the evidence in such a way to persuade the judge? And I mean, I'd also pause at this moment to say it's so important to remember that in this case, the accused were given an early, essentially, the case was dismissed without them having to answer to it. And so this wasn't a case of the judge and the court having to weigh up evidence on both sides and deciding that nothing went wrong here. It was rather, as you've said, the judge saying and turning to the NPA and to their investigators and saying, you have simply failed to present a case strong enough here to even warrant the accused having to answer. And I mean, this is why this SCA case is so important. If the NPA are successful here, it does, of course, provide them with another opportunity to get this case over the line. But not just this case, they have so many much larger state capture cases coming up over the next year or so. And, you know, their failures in this one have really, I think, undermined the public's trust in their ability to get those other cases over the line.
Yeah, I mean, she says there's no doubt that this money, this taxpayers' money is no longer in the fiscus, right? But she did talk about she described it as the lackadaisical manner in which the matter was investigated, particularly by police. And I wonder whether it's a cop-out now, Michael, to say, well, actually, the judge didn't understand what we were trying to say.
Look, I think it is a little bit of a cop-out, Michelle. As I've said, I think there's a possibility that the SCA may find that the judge was too harsh in the assessment and may have erred in some aspects of the law. That's certainly what the NPA is hoping will come about. But I think we go back to this fundamental question that you've raised, is that I don't think anyone can argue on the basis of the case that was presented to the High Court that the NPA, and when I say the NPA, I mean more broadly the team that worked on this. This was the Hawks investigators, the NPA, just didn't do enough to get what they described themselves was a landmark case to the point it needed to be. And so, as you've said, these kind of rudimentary errors about not going the extra mile to ensure that authenticity and admissibility of documents and evidence doesn't become a focal point of the case, to allow themselves to get dragged into these now multi-year arguments around admissibility long before we get to the merits of the case. You know, it's been described as an own goal before, and I think regardless of the outcome, it will always be seen as that. They obviously desperately want a chance to set that right, but they've lost a huge amount of momentum, and as I keep saying, also public trust in this failure.
Look, we all want a retry of this case, don't we? Because the fact of the matter is the money is gone. There was millions of rand promised to poor black farmers in the Free State. We came to know it as the Vrede Dairy Project scam. We know that money never went to the intended beneficiaries. So can we please check that words are spelt correctly, that documents are authenticated before we admit it into evidence? It should be a slam dunk.
Absolutely. Michelle, you raising the Vrede dairy farm is so important as a reminder to everyone listening that the Nulane case is the foundational alleged corruption at the basis of the larger Vrede dairy scam. And of course, we shouldn't forget that that matter was struck from the roll as well last year in one more case, state capture case, that the NPA has failed to get across the line. As you've said, there are so many, the entire state and everyone in South Africa was a victim of state capture and its effect on institutions. But what happened in the Free State was one of the most egregious cases of vulnerable South Africans who were relying on the state being completely, devastatingly disadvantaged by the kind of iniquitous corruption that was the foundation here. And so pursuing accountability is absolutely so important. And so if the NPA is given another chance to do this, obviously we must all watch very closely. But as I've said as well, there are so many other cases coming up over the next few years, and the NPA cannot afford to make arrests, get cases enrolled, and then, as was the case in this case, have it slowly fall apart when the matter eventually gets to trial, because those kinds of delays to accountability really are devastating in so many ways.
Yeah, when you're just so close to the finish line, watching those rudimentary issues in the case. Michael, let me thank you for your time this afternoon. It's such an incredibly important story, and we'll wait and see when the SCA does make its decision on this case. Michael Marchant is the head of investigations at Open Secrets.